Buongiorno a tutti. Good morning. I'd like to thank you, Studio Bonini and CUOA, for this presentation about IP matters in Brazil, especially transfer of technology. Initially, I'd like to talk about our firm that was founded in 1978 and operates in all issues concerning IP matters in Brazil: patents, trademarks, copyright, licensing. And, for example, in 2011, we appointed the Brazilian Analysis Advocacia and Who is Who Legal, 2011, and also Chambers Global, ranked in band 1 of the leading firm and attorney in the area of intellectual property. We're a member of AIPPI, INTA, Marx, ECTA, GRUER, FICPI, that all the lawyers of the firm attend annually said meetings. Concerning technology transfer in Brazil, we have indicative regulation and mandatory regulation. 1.1, for example, trade secret or know-how only under mandatory regulation. In other words, the Brazilian Patent Office is the agency of the Brazilian government in charge of trademarks, patents, and licensing. Brazil is the only country of the world when a contract, I would say a commercial contract concerning licensing or patents or trademarks or know-how is an obligation mandatory to approve. And 1.2, we have fiscal, which has to do mainly the income tax by the Brazilian company that acquired the technology, and the remittance of foreign currency, the intellectual property and industrial property, also antitrust and unfair competition, and of course, the foreign capital. Elements of trade secret is an information, of course. It is a secret. There is an intention to keep it secret. It has an industrial application, but in some countries also in trade, finance, among others, not in Brazil. Brazil only in industrial application. The legislation of transfer of technology includes the following objects, as I mentioned: patents, trademarks, technical knowledge. The first law, 4131/1962, which regulates foreign capital, and the Article 12 states the question concerning royalties. And also, Decree, January 20, 1964, defines in Article 10 royalties, and Article 11 another issues. A very important for you, for your company, a very important mention is the question concerning the maximum royalty to be allowed to remittance abroad. Concerning the percent of royalties, we have two situations in Brazil. The first, I would say, legislation occurred in Ordinance number 436 from 1958, issued by Minister of Finance, is still in force, and laws, and the other laws. And the PTO, the Brazilian Patent Office, applies said legislation concerning the remittance of royalties and the tax deductibility. But there's a very important situation, the law 8383 from 1991, that allows the remittance of royalties between parent companies abroad and their subsidiaries in Brazil, concerning patent, trademarks, and know-how. Is very important for foreign companies with subsidiaries in Brazil. It is possible to remittance of royalties, as I mentioned. And the remuneration of, I would say, of licensing, of agreements, is based on a percentage over the net sales price of the products. And you can define net sales price The gross selling price less trade, quantity, cash discounts, or commissions. Depends of negotiation between the parties. And the percentage of royalties is from 1 up to 5%, in accordance with the ordinance, as I mentioned before, 436 for 1958, issued by the Finance Ministry. Is to enforce. And I repeat, the PTO applies said old, very, very old legislation. The kinds of contracts, patent exploitation license agreements. It's very important the difference between the number 4.1 and 4.3. I explain. Patent exploitation license agreement. Technology already filed or granted as a patent in Brazil. As a patent in Brazil. It's a license. And 4.3, supply of technology agreement. Technology not filed or granted as a patent in Brazil. In 4.1, the foreign company grants only a license for a Brazilian company or for the subsidiary in Brazil. And in 4.3, the Brazilian company or the subsidiary acquire the technology. There's a very important difference between licensing and know-how. 4.3 is know-how, 4.1 is only license. The owner in 4.1 is the owner of the patent that grants only a license. Trademark license agreements and technical assistance services agreement. I explain. The owner grants a license to the licensee to use the patent during a certain period of time or during the validity of the patent in Brazil. It's a very important point, the number 4. It is possible to present at the Brazilian Patent Office an agreement concerning a patent not yet granted, only filed in Brazil. Once the patent is granted, the remittance of payments may retract to the date of presentation of the agreement at the PTO. It's a very, very important situation for foreign companies. The remuneration is also based on percentage over the net sales price, 1 to up to 5%. The term, normally the term of the agreement is the term of the value of the patent. This is a very interesting situation. If a company has a number of products under technology covered by patents in Brazil, which intend to license it to its subsidiary, it is advisable that separate agreements are executed for each product, and not to execute one agreement covering, for example, 6 lines of products. Why? Said strategy is based on the fact that the subsidiary must present on an estimated basis, year by year, physical production, net sales of the amounts to be paid to the supplier concerning each product. With one agreement for each product, it's easier for the licensee to present that estimation, and for the PTO, of course, to analyze the same. In other words, if a variety of products are in the same agreement, it is quite impossible to the Brazilian Patent Office to distinguish the remuneration for each product. Then I also advisable that each patent, each contract. The question concerning territory is not possible concerning the Brazilian antitrust law. You cannot fix the territory, not limit, for example, to Brazil or South America or Europe or Asia or India, for example. It is impossible. The licensor will send technical personnel during a period of time. It is possible. In disputes arising the agreement, it is possible a clause indicating a court of arbitration, provided that the Brazilian law is applicable. Trademark license agreements. A licensor grants to license the right to use trademark during a certain period of time. And second paragraph is very different situation in remuneration. In the first paragraph, is regarding parent company and subsidiary in Brazil. The remuneration is only up to 1% over the net sales price. The second paragraph, in case of agreements in which the parties do not have a corporate liaison, the percentage for the remittance of royalties can be between, I would say, 5 to 10, provided that it's well justified to the Brazilian Patent Office. It's a very important difference between the first and the second paragraph. These are only some procedures concerning the number of trademarks to be licensed, the payments. The agreement can be exclusive or non-exclusive. Depends on the negotiation between the parties. The same situation, they dispute a court of arbitration. And supply of technology agreement. Technology not filed or granted as a patent in Brazil. It's a know-how agreement. Another very important situation concerning remuneration, the effective date. We advise our clients that the effective date means the date on which the agreement is presented to the PTO. It's very important concerning payments and not to the date of signature of the agreement. The advantage is that the PTO, for example, issues official actions and the parties take a time to comply. Then, upon approval of the agreement by the PTO, the remittance of royalties may retroact to the date of the presentation of the agreement at the Brazilian Patent Office. In some cases, it's very important to fix that kind of clause. The remuneration is up to 5. Secrecy. The PTO accepts that the term of secrecy can be established as 5 years, counted from the date of transmission of each technical information from the supplier to the receptor in Brazil. The term 5 years, renewal for more than 5 years. The same situation concerning patents, because I have control of the time here. It is possible to the supplier, you send technical personnel during a period of time to assist the technical personnel of the receptor, the Brazilian company or subsidiary in Brazil. And the remuneration of the same must be included in the royalties. Very important situation. And finally, technical assistance services agreement. What means? This kind of agreement is related to engineering services regarding the startup of industrial facilities or industrial equipment or the implementation of a new industrial plant, as well as plant adaptation, modernization, enlargement for the industrial manufacturer. And this kind of agreement is calculated on an hourly basis, not a percentage. Only is hourly basis, in accordance with the services to be rendered by the supplier. In the clause of remuneration, the parties should establish the total amount to be paid to the supplier of the services.